Welcome to Why Daddy Never Cries podcast with your host, Chuck Kelleher. At Why Daddy Never Cries, we'll explore the lives surrounding daddies, their children, divorce, and silent domestic violence. We'll hear real-life horror stories from unsung heroes fighting for the ability to stay in their children's lives. We'll get those voices heard and hopefully find solutions before you lunatics burn the whole place to the ground. Hang in there, daddies. Chuck's here.
Chuck Kelleher and Why Daddy Never Cries are providing his podcast as a public service. I've known Chuck for 45 years, and he's neither a lawyer nor a mental health professional. He's not a doctor nor a rogue scholar by any stretch of the imagination. Chuck is simply a guy who's lived in hell for 20 years. Once he found a way out, he drew a map to help others navigate their own way home. The views and opinions expressed by Why Daddy Never Cries, employees, or our guests are their own. Guest appearance on the program do not imply an endorsement of them, their opinions, or any entity they represent. And please, for the love of God, if you have any questions or fears about your unique circumstances, please contact a lawyer, a religious leader of your choice, or a medical professional in your area. Don't fuck this up, brothers, because we're all in this together.
We'd like to thank our sponsor, VosG2, for helping small and medium-sized businesses elevate their brand perception with design. Take your brand to the next level at VosG2.com. We'd also like to thank Harry Duran and his team at Fullcast for their amazing assistance. If you're planning a podcast and you haven't contacted Fullcast, you might as well call your show Podfade.
Ladies and gentlemen, we'd like to welcome to the show today Larry DeMarco, self-representative litigant coach. Larry, how's it going, brother?
Real well. Hey, Chuck, thanks for having me.
Hey, thanks for coming, and really appreciate an attorney who's helping people save money by teaching them how to do it themselves. I mean, what greater calling could you have? Because we've all been destroyed financially by this stuff.
Thanks for that. I recognized early in my legal career that it's an inefficient system where lawyers are charging several $100s an hour for people who don't have disposable income, but they still need to protect their families. So I knew there had to be a less expensive way, and making online free resources and figuring out a way to help them as efficiently as possible is a goal of mine, and it's been a life calling, and I know how necessary it is.
Well, back in the day, I was making between $11 and $15 an hour, and my legal tab went up to, I think, $120 by the end of it, $120,000 before it was done. So I can see if they're taking $120 from an $11 an hour guy, if got any more money, they're going to get it from someone's bank account.
Well, but that's the average salary. I mean, the average working person lives paycheck to paycheck. So how are you going to be able to pay a legal bill, but it doesn't make you less of a father? So, or parent. I don't mean to just speak from my own perspective as a man. Yeah. I recognize that this faces women as well. So, and there's a need for the type of free or low-cost resources that I produce.
Well, let's get into that. So they always say, you never do your own brain surgery, you never become your own attorney. But there are cases where you should or shouldn't self-represent. What do you recommend? Are there absolutely critical to make sure you have an attorney with you by your side cases? I would assume murder and other stuff like that. You don't go in by yourself.
I don't recommend 100% self-represented status, because study that shows what a disadvantage a self-represented litigant has, except when absolutely necessary. Chuck, and I love your question. I recommend people becoming what I would call their own paralegal, but still getting something that's called a limited scope attorney. Another way of saying that is getting someone to agree on unbundled services. That's a term in my profession. That is actually the way family law should be. And there always should be resources that are easy to find for the average person to handle most of the case themselves.
What do you mean by unbundled services?
Traditional representation is what the most common family law lawyer does because it's more lucrative. And in fairness to my profession, lawyers don't want to be sued, and they feel obligated by their own code of ethics to be zealous advocates and to protect their client as a zealous advocate and ensure the best representation. Imposing that burden requires, in my opinion, a lawyer to overspend. But there's a way within the code of ethics for the attorney to say, I'll only give you what you need. You are going to be your primary advocate, and I will help you do what you can't do. Why this works, especially in family court, is because it's mostly logical. It's mostly intuitive. The code for parents for custody litigation is somewhat simple. It's the best interest standard of the child, which often just means whatever the judge wants to do. But there are custody factors that you're applying, safety being one of the most important, and the emotional well-being of the child. So you can apply some common sense to a custody decision and just show your fitness as a parent or your parenting skills and what you do for your children. Then get past your own emotions or, what you can't do, such as argue in court. You want to show whatever document you prepare, what theory of the case you're pursuing, basically the general strategy you want to run by a third party in an hour consultation. So you might not have been able to afford 120,000, but you probably could have afforded 1,200. You would have found a way, and it wouldn't have bankrupted you. You would have lost a vacation or 2 or 3 or 4 that year. It's not a life-changing thing that creates a second trauma from already separating with someone that you hopefully loved at one point and still should be treating each other like family members or co-parents. So the unbundled service is, I hate to say, new or somewhat revolutionary. The lawyers are particularly reluctant to do it because they're making less. They don't get to a bill for all the time they do.
Okay.
They're forced to give flat rates and say, I'll go to court, but it's going to cost you 4 hours, $500, $750, $1,000, whatever it's going to be. But you can handle that. You have a trial. You need someone to speak with you and cross-examine expert witnesses. That's something that you can do. So the word is unbundled and limited scope representation. So if you're hit in a custody situation, that's your search word looking for someone, so you know what you're going to have to pay, a flat fee for whatever need you have.
Now, a lot of our cases, as you are more than well aware, have that extra layer of nonsense. The children are involved. They're being either kept from one parent or the other. They're being used for more child support or to give less time, or sometimes just as a punishment for parents. These are tougher cases. How do you help somebody keep their emotion out of it by being with them in the room?
Well, a lawyer passes the bar, which means to become an attorney, you take a bar exam, you graduate law school. It means you are allowed to pass the bar of the court to speak to the judge.
Right.
So you're not emotionally invested. You're not thinking of losing your children. You are not suffering from a breakup. You don't have an adrenaline rush.
Oh.
You don't have your nerves pounding. Ideally, a calm, cool, experienced cat or litigator who is there as a seasoned professional to sift through any emotion and to just argue the facts of your case.
Yeah.
A lot of litigants are more thinking of the emotion and how it affects them. Your lawyer actually is a translator to translate the emotion and your self-absorbed injured self. I'm not really saying that litigants are bad people because they're fighting.
Okay.
It's just you're suffering, you're traumatized. You just lost the most important relationship in your life and you're threatened or you're at risk of not seeing your children nearly as much as you used to. So you're naturally emotional, and that's what the lawyer is designed to do, protect you from being a quote unquote fool of a client by representing yourself. It's because of that emotion and that how difficult it is for people to separate themselves from intense pain and think reasonably because of a fight or flight response.
I totally get that and can empathize, hands down. I've had 3 law firms working for me throughout this nonsense. And I don't remember which one of my attorneys, but one of them said, today I'm going to have to be the asshole. So you keep your mouth shut. Let me be the asshole. The judge can yell at me. It's not going to reflect on you. That said, how do you think judges perceive pro se litigants?
So one of the reasons why, and studies show, that there is a prejudice against self-represented litigants is because, number one, the judge doesn't want to babysit that emotion.
Yeah.
So people show up talking about things that aren't relevant. She slept with a neighbor. He betrayed me. He's mean to me. The dirty laundry that people want to emote and talk about that's not relevant. It wastes the court's time. The court doesn't want to coach witnesses or litigants and tell them what to do, but there's actually a whole list of things that judges in a study said pro se litigants do things that they're not supposed to do, and they ask the judge for help for things that you're not supposed to help a self-represented litigant.
Right.
So that's a prejudgment that the court makes by you not being
Prepared?
with a lawyer or be prepared, that you're not prepared, and that the judges don't have enough time when prepared lawyers come in, let alone to deal with the noise that a self-represented litigant brings in. And most judges are actually, contrary to a lot of, victims of family court, judges do want to make the right decisions. Problem is, they don't always have the best information to base their decisions. They don't always have enough time in court because the system is so strained by the latchkey generation and the frequency of divorces, how many people actually need family court. So it's an overburdened system, which causes some of this extra stress for judges when they have to deal with 9 out of 10 people in Philadelphia who show up without lawyers. So it makes actually the court's job harder because they want order. They want things to be easy, and litigants make things harder. So the perception is negative against the litigant because they don't know what they should most of the time.
And I had that problem the first time I went. I forgot to stand when I talked, and I realized it halfway through and like, oh, I'm supposed to be getting up, and I apologized. And the judge laughed a little, but a little.
I understand.
All right. So what are some of the challenges that a pro se litigant would face? And what kind of strategies would you recommend for someone who's starting off?
It's information. Mostly they don't know where to look or where to find the information that they need, which is, again, where I suggest people either use my free resources online, perhaps if they can afford a premium product that gives more information faster and easier. I have a low-cost boot camp for self-represented litigants.
Oh, excellent.
Which is actually like a paralegal training course, a 10-hour crash course with all necessary resources indexed neatly for you, not locally.
Okay.
It's a national program for what I would call the majority jurisdiction, but it tells you where to look and how to find what you need. Another resource that I recommend is ChatGPT, a custom chat produced by a company called Research AI, which is called Law, Legal and Contracts, Not a Lawyer. Hopefully we can put the link in the podcast.
100%. We'll have all the show links, and any sites you recommend will all be in, as usual, in the show notes.
Well, this is important because what it is, it's a new age attorney. It's a chat bot that's trained to speak like a lawyer in any state of the country and knows family law. So the biggest challenge, again, this is a roundabout way of saying, is it's information. So I don't recommend that a self-represented litigant start by him or herself. You should be looking at resources or pay the first hour for a limited scope lawyer that can give you some type of plan on where to research or how to prepare. And my online videos are a great place to start.
Beautiful. Again, all the links will be in the show notes, folks. You know where to find them. Information, obviously, is one thing. Know what you're doing if you're going to get in the game. Every case is unique, so it's really hard to package one size fits all. But if there's a certain pattern, are there any pitfalls or traps that pro se litigants fall into that would be easy for an attorney to be like, oh, I got a pro se, I'm going to ask XYZ because they always say ABW?
Yeah, I would say that a pitfall is to think the case is about you. We're often under assault. We're often facing false allegations, or there's a natural way of, in a custody battle, to present what's best on one side and what's bad about you. So the day they go into court is often the worst day of their lives, where they're hearing all their own dirty laundry being displayed in the middle of a public courtroom and feeling that you have to defend yourself. So the important thing is to remember that it's not personal. It's not about you. The lawyer or even your ex is presenting the facts that benefit your ex the most and which are least favorable to you.
Right.
So the pitfall is to take things personally. Another word of advice is never, quote unquote, hate your enemy, never show your emotions in court. So these are things that are naturally easy to do. It's instinctual, it's reflexive to be emotional, to fight or flight, to defend yourself. But in a courtroom, it's important to distance yourself from that emotion and just remember your notes. The best way to avoid against a pitfall is preparation, over preparation.
And a good friend of mine once said, ink it, don't think it. So if you have ideas, write them down. Don't think you're going to remember them on the spot. Have your flip cards, your notebook, whatever it is that you need to remember where you're going to go next. Like the show, every time I stumble over my own lips. Empowering the litigant. I know I don't read well because I'm dyslexic. So when I get to legal documents and stuff, the words are bouncing all over the page. What would you do to empower somebody to take that step, to trust in their own knowledge? Or not because it wouldn't be your own knowledge because you were researching, but their own ability to do the right thing for their family?
So my approach has been to organize information and recommend preparation, because when you're prepared, it's harder to be thrown off your game. So the more that you go over your something I call an elevator pitch, which is that if you have 30 seconds to explain to a judge what your case is about, you can give that 30 seconds, you have it memorized, and you know what to say. Then there's a second stage is the summary. So suppose the judge gives you 2 minutes. What are the strongest points that you could make in 2 or 3 minutes? Then the next stage of knowing your case is your case in chief, where the judge says, okay, you got a half an hour, call your first witness. And then you prepare all the bullet points of each item that you feel that you need to convey in your case in chief, whether it's your own testimony and you want to talk about the 16 best interest factors related to a custody decision, and you go through one. How do you support the emotional needs of your child? 2, describe the safety, what home that you've prepared. And 3, just going right down all the items. You write them down just in the code, and you rank them based upon your strengths, and then you make the key points that you want to bring out when you're presenting testimony, whether it's your own testimony or whether you call a parent or grandparent or uncle who observes you with the child, and have each different level. The 30 seconds when the judge says, okay, last word, judge, I just want to remind you, 30 seconds. Or the judge says, give me a closing, you got 3 minutes, have your best, strongest 3-minute points. And then the case in chief, where each witness, each little point, each exhibit that you want to bring up or bring in. So preparation is the most important thing for a self-represented litigant.
When you're doing your, what'd you call it when your buffet bar legal services?
Sure. Unbundled. That's a buffet bar is actually a really good way of putting it. It's limited scope or unbundled services, kind of like a tray of different appetizers where you get to pick and choose your meal or what parts do you need. Good analogy, by the way.
Thanks. Like cases like mine, which involved false allegations, domestic violence, parent alienation, removing the kids from the jurisdiction, but it's okay because they're with the mother. All that fun stuff that went along with it. How do you not get buried in legal preparation? Because I could almost justify the tens of hundreds of hours put in by my attorneys to prepare for my case.
There are elements of a parental alienation case that you need to prove, just like any other type of case. With parental alienation, the problem is, just by definition of parental alienation, there's the appearance of contact refusal, that a child is preferring one parent over the other or making a false allegation against one parent or the other. So you have to prove the elements of parental alienation, which takes you into something called the 5-factor model. To establish parental alienation. There's 8 alienating behaviors. So there's elements that you hit to be able to establish this child is more likely alienated rather than abused or a victim of what the other side is alleging.
Okay.
And you also have to present 17 alienating strategies, all of which go within parental alienation. If you're a self-represented litigant, you're not going to have the expert witness because they want something like $5,000 to $10,000, you're going to have to establish yourself. How do you do that? Through the elements of parental alienation, and then you're going to argue on the parent that is more likely to promote a relationship between the child and the other parent than the other parent, because in contrast, he or she, depending upon your perspective,
Right.
is putting my children or the children against me falsely. And you do it through those factors, the 5-factor models, 8 alienating behaviors, and the 17 alienating strategies. So that's a distinct element of what you have to prove other than the best interest factors, because there are false allegations that you're dangerous. And that's an element of custody, which is the safer parent taking care of the child's needs. So you're playing defense to show how and why there's false evidence against you, if that all made sense.
Totally. So you play defense, but you're not defensive.
Sure. When you have false allegations, there are elements that you can prove. And I have on my YouTube channel, there's a playlist with 45 different videos. And I'll recommend to people, if you watch every parental alienation video on my playlist, is the equivalent of a full weekend, if not 2 weekends, of conference videos at a parental alienation study group conference.
Wow, that's awesome. And I've seen the videos. They're really good. And those links will, again, be in the show notes as well. How long have you been doing this, buddy?
Practicing law 32 years now. I was going through my own case on and off for about 10 years, and I've been helping self-represented litigants for a full 5 years.
Like the rest of us, you kind of got into this after you went through your own and kind of saw how the system is.
Yeah, that's one thing about creating free resources. There's really no money in free.
Mm-hmm.
You're not earning anything. So it was more of a hobby, or it was more something that I knew that needed to be done, but I don't earn a living doing that. And this is something that I want people to understand. If I was practicing in family court, I don't know how much time I would or could have dedicated to a complete free library. I don't think any practicing attorney who represents people can have the capacity to create something for free when your trade is a litigator.
Right.
Except limited scope resources, but I have a kind of a national clientele. The model of YouTube is that you really have to cover a whole country, if not the whole world, not so much Delaware County or Philadelphia, Pennsylvania.
Yeah.
So the free resources are global, but I do want people to understand I don't have an active family law practice. I'm actually a personal injury attorney, and this is just a way of me giving back.
Nice. Have you seen changes in the family court?
I would say that seems to be more openness to limited scope than there was, say, 30 years ago, out of necessity, because you have to, because the system is collapsing, because people do not have the money. So courts are more open than they used to be, out of necessity.
Okay.
So it's still not where it should be. I do notice more of an acceptance of pro se litigants and more lawyers willing to have a flat rate for an as needed service.
Makes sense. Now, Larry and I spent 2 weekends together, one up in Toronto where we both spoke at Men's and Families, a conference up there. And then we were just at PSA Consortium in Connecticut. Larry's 100% right when it comes to people just wanting to tell their story. And we saw it at both conferences. We've seen it ourselves in trying to tell our tale is you tend to give too much of the backstory and you don't get to the point and you lose your audience. So that is definitely something I think if you're going to practice, the elevator pitch is perfect. It's almost like sales 101. You got to have your 30, your 60, your 90-minute pitches, and then your 5, your 10, your half hour.
Yeah, you always want your opportunity, like you just said, to tell your story or to make your case. But the whole idea behind that structure, as I explained to you, is you can always default into shorter if the judge wants to cut you off and says, you've got a minute to close up. You have that minute pre-prepared because you, number one, over-prepared, but number two, you prepared based upon how much of time that you have to make your case. So that's the theory behind that. You're flexible because you don't know what you're going to see. Sometimes judge says, okay, I got questions for you. And the judge wants to be done in 5 minutes. Other times the judge puts their feet up, sits back and says, your case, and doesn't seem to be listening. But the point is, The courtroom is yours, and you can present, and the judge gives you the opportunity to present whatever evidence you want. So you want to have both things covered. You never want to get caught unprepared and say, well, I don't have anything to
Right.
say because I wasn't prepared. I do have a 30-second elevator pitch, though, but then I'm going to shut up. And then your other side is making a detailed 20-minute argument. You want to really be prepared for both. So it's a real time commitment to represent yourself. And again, I have more detailed steps available online for anyone who wants support.
I advise you all to look at it because family court's a closed door session, which I know it's to protect the families and all that, but it doesn't help because things get lost from case to case to case. So if you've never been through this before, I 100% recommend checking out Larry's videos because you'll at least know what you're getting into before you get there. And then maybe you'll have a better idea what you need to do or say while you're there.
So and anyone who does that, please feel free to leave comments, or if there's something that's not covered that you want covered, I'm happy to do that to enable people to have some questions answered.
Nice.
And the chatbot that was produced is another great Q&A that I think is going to revolutionize family court and law, the ability to have pre-custom chats, legal and contracts, not a lawyer, has the information of a lawyer that can help respond to hypotheticals or to a situation that you present, so long as you phrase it in a hypothetical, because it doesn't want to get sued. The company who produced it doesn't want to get sued.
Right.
They can't say it's legal advice, but it can be just as helpful.
Yeah, it's funny. I was using chat today and it had to keep reminding me that, hey, these are sensitive subjects you're talking about. So I had to go into my chat and say, this is for research. I'm not looking to hurt anybody. I'm just looking for facts. And then it was able to give me what I needed.
The amount of money that lawyers overcharge is what these chats aim to reduce. Same thing with my online program, by the way, and the videos. It's an attempt to give you a very deeply discounted, low-cost education so that you have the same general knowledge as a lawyer who went through law school or a paralegal who has the training from a family court lawyer.
Now, have you seen your name written on the bathroom walls in the other law firms for family court?
No.
Nobody's got the bullseye out for you yet for giving away.
Not that I know of. Oh, it's funny that you say that. No, do I have bullseyes? I think that there's enough people doing this. It's funny, when I was active within my bar association telling other lawyers what I was doing, I learned to keep quiet. Really, really soon, the outrage from the practitioners, it's not to put out of business any lawyer. It's meant to transform the legal system so that lawyers only charge you for what you can't do. I think the system would have a lot less problems with it if lawyers just assisted people with what they couldn't do themselves, rather than charge people for what they couldn't afford and what they actually could do themselves anyway.
All right, this is kind of a loaded question. I just thought of it now. Doesn't that really only help the educated? Because the uneducated are going to get screwed because they're not going to know how to navigate any of this stuff.
Well, there's two things there that, when you say only the educated, it's true, it's not for everyone, and it's going to be harder for some. But this is what the benefit of learning through video. You don't have to read. So if you have trouble reading small print, or if you have trouble reading at a higher grade level, you can still get it auditorily. You can still get it spoken to you. So it's easier to learn through video, number one. Number two, if you have an issue with reading and writing, there's one thing that generative AI does. You can ask the law to be simplified for you in more simple terms, reduce the grade level.
Wow.
If you have trouble reading, or if it takes you too long to read, you can have it speak to you, and you can take your own notes or just overlearn it and memorize it. There's still a way to get around, or get someone to help you as well, because now you're not having to pay for it. You can get it lower cost with a custom chat that, again, if you click a speaker icon, you can have a conversation with these chats.
So you don't have to worry about typing. You can just talk into your problems or your issues. It'll get back to you. And then if you don't understand it, be like,
That's right.
Could you simplify that another level?
That's right.
Can you simplify that yet again?
That's right.
That's amazing.
But of course, there's an advantage to people who can help themselves. There's no doubt about it.
Sure.
There's not a solution necessarily for everyone, but there's certainly more solutions for a greater number of people at a much lower cost.
I like that. I like that a lot. All right, we're both advocates. What other changes do you think we need to fight for?
I do want to see limited immunity, not the absolute immunity for corrupt and malicious behavior or orders. So that is one. More transparency in the legal system. I think the way we select judges should be open and should be merit selected, whether it be through candidate selection or bar association ratings. But the more merit that goes behind any procedure that you pursue, the better.
Mm-hmm.
I believe that more transparency in the courtroom, such as judges disclosing what financial interest they have with the counsel,
Mm.
whatever attorney appears on front of them, or litigants for that matter. Cameras in the courtroom, not for the public or media, but for the parties, so that you're not dependent upon a transcript or a recording. You get a full account of actually what happened in every decision that was made for purposes of appeal. And an independent judicial ethics board by non-judges, but an independent review body, so that judges are held accountable for the decisions that they make. So those are a whole bunch of favorites, and I actually have a family court reform playlist on my YouTube channel, which viewers can find and
Nice.
go see all the ones that I believe in. Shared parenting is another one. There should be a presumption by clear and convincing evidence that a child has access to both parents as close to equal as practically possible.
That should be really a home run and simple. As soon as you walk into court, it's 50-50 unless the parents or situations dictate otherwise. Like if you're a parent who works at night, you can't get your kids for overnights. It's not going to happen for you because you work nights. There's not going to be no one there to supervise the child. So you need to figure out another way.
And I also think that false allegations should be fraud or lying under oath, and maliciously false allegations in court. The laws against it should be enforced is another big one, because there's too much incentive to lie and it causes too much harm to do it and get away with it, so that once someone is caught, there should be some type of consequence. Otherwise, every case has unchecked wild facts that create too much trouble to sort through, time and expense to both the court and the litigants.
And just to show you how crazy that is, I have a friend down in New Zealand whose ex-wife, and I saw the court documents, accused him of throwing her out of an 11-story window in the middle of Auckland. No scratches. 11 stories. That's 110 feet. You're not surviving that. No scratches. But he still hasn't seen his kid because they just want to make sure he's not violent. Again, there's other circumstances and stuff, but that's one that you should look at as a logical human being and go, something's not quite right here. But they don't. Now, bringing it back around, holding judges accountable. Explain to our audience about that. Like, judges have immunity.
So the law is from Stump versus Sparkman, which is a Supreme Court case, that a judge was held not liable for ordering a special needs minor to be sterilized at the request of their guardian. The ruling of the court was that judges were still immune from what's called malicious and corrupt orders. So the argument is that judges have immunity from negligence,
Okay.
for making mistakes, for making errors in discretion. You can't sue a judge for being bad at his or her job. But what you should be able to do is sue when it's proven that a judge did something clearly outside the bounds on the bench, but with a motivation or with a deliberate malice or corrupt motive. So if you can establish that, then judges should have civil liability. They already have criminal liability. It's civil liability, which is the issue here.
Okay.
And as I mentioned, along with that, you should also have an independent review body. But if it's proven, even by some type of admission or some type of strong evidence, that a judge did something based upon a bribe or malice or corruption, then that judge should be subject to civil liability.
But they have criminal liability. A judge can go to jail for something.
They already have criminal liability. The problem where that's considered not to be effective is because of how hard it is to prove,
Right.
beyond a reasonable doubt, which means 95% sure. but you can have a lesser standard, such as clear and convincing standard. You can hold judges liable for maybe an increased standard, if not preponderance of the evidence, or a requirement. Again, they're immune. They have quasi immunity for negligence when they're acting through their judicial capacity.
Yeah.
But even when on the bench acting in your judicial capacity, if you order someone's constitutional rights violated illegally, clearly illegally, and based upon a malintent, something that's proven that the intent of a judge is proven to be malicious or corrupt, meaning a bribe or meaning for the wrong reason, then there should be civil liability.
As long as it doesn't jam you up. Do you have any cases that you know of where a judge got in trouble?
We read about it. Sure. In Philadelphia, there was a judge that was suspended for 6 months for holding people in contempt for reasons that were clearly non-contemptible, just because she wanted to or because she can.
Okay.
I always would say to other lawyers, why does this judge do this? Because he or she can.
Yeah.
Clearly there's no reason for doing it. No, judges, really, really bad ones, do get caught. There's a book called The Luzerne County Railroad, written by Larry DeMarco,
Okay.
that discuss absolutely despicable behavior by a judge, where the judge was former partners or some type of godparent of another lawyer, and every ruling suspended reason in favor of his family friend that they were eating lunch with at every break.
Right.
So, Larry DeMarco wrote a book on it. Incidentally, I also cover that on my YouTube channel, and he described what went on. So there's situations where judges are immune.
That's unfortunate. Absolute power corrupts. And when you're unchecked, you have the ability, not all of them, but you have the ability to stray a little.
No, I did a video about that too, related to the Stanford prison experiment.
Oh,
The idea is that corruption comes not necessarily from individuals, but judges have more powerful than lawmakers. I believe the Supreme Court's more powerful than the president in terms of checks and balances, because there's no checks and balances on the Supreme Court of the United States. So when you give a body that type of power with a lifetime appointment and absolute immunity, it's not that the judges are bad people. It's not that we're appointing bad people. It's just that much unchecked power creates a situation, according to Lombardo's experiment within the Stanford prison experiment, when you give no transparency and no accountability, you risk the greatest bad behavior based upon a bad system, not bad people. I believe advocates should not be taking names down. You should fight for a reform of the system, and that way you don't get thrown in jail, but you can still make things better.
that makes sense. That makes a lot of sense. Obviously, the show is mostly dealing with family law and divorce allegations, keeping children in their parents' lives. Is there any instance in family law where you would recommend somebody right off the bat go straight for counsel and don't even think about self-litigating?
I believe false allegations and protection from abuse orders or contempt, or either, having a protection from abuse order can so change the direction of your case that the stakes are so high, even though it seems like an unfair expense. If someone is saying, you hit me and there's a bruise, your path is so treacherous.
That makes sense.
Without fighting to defend that order, I recommend counsel. And if you have the money, I strongly recommend not leaving that to chance.
Yeah. No, I was scared. I was scared.
You need every benefit, and then wear a body cam every time you're around the exchanges if you're concerned about it, so that you have to protect yourself. I think false allegations of abuse where you could have an order, because then if someone has an order on you, then you are at severe risk of being beaten up. If there's an order against you, you are a target because you can't defend yourself.
I know that feeling.
Yeah, but an order, a stay away order, is very similar because it's one half step away from being locked up.
If prison's on the line, get yourself an attorney.
I would.
That makes sense. All right, Larry, first of all, thank you very much for sharing all this with us. And again, folks, if you're not looking at Larry's stuff and you're going through this, you're missing a great opportunity to save your family. Where can they find you, Larry?
Thanks, Chuck. My pleasure. You can find me at thelawcenter.net, where I have my website, the YouTube channel, The Law Center. I should come up first because I've done enough videos in comparison to other law centers, but my last name is DeMarco. If you type DeMarco, The Law Center, that comes right up.
Nice.
So those are the two big ones that you can find all resources from those two. I also have a Facebook group, Child Custody Support by the Law Center. You can come and join my Facebook group. And I also have the online program, the Self-Represented Family Law Custody Boot Camp for self-represented litigants in custody court. Again, but you can find that on my website. Thanks for asking.
Beautiful. We're going to have Larry on a couple of shows because there's so much out there that we've just got to talk about in the next at least 6 months. Larry, thank you, brother. Now it's time to go play dad. Always good seeing you, and I'll talk to you this week.
Good to see you as well. Thanks, Chuck.
All right, brother. We'll talk. We actually rolled through almost everything. How technology is changing the landscape for pro litigants. We touch base on favorite apps and platforms. And I tell you, again, if you're not checking out Larry's resources on YouTube and on his website, you're going in with one hand tied behind your back. All right, Joe, take us on home.
We must get our voices out there. Send us your stories to whydaddynevercries at Gmail or Why Daddy Never Cries on Facebook. Remember, this is a daily and sometimes hourly struggle, so follow us on Daddy Never Cries at Twitter and Why Daddy Never Cries on Instagram, and let your voice be heard. Let's end the fatherless children syndrome that's plaguing this world.
The team of Why Daddy Never Cries consists of Joe, the voice of reason, Nicole Kelleher, and Scott Hall. Thanks, everybody.
You can't change what happened to you, brothers. What you can control, however, is how you react to every situation. So you got to figure out how to make it work for you. And when life gave me lemons, I said to hell with a glass. I'm making an international lemonade franchise. So until next time, you've got this, Daddy.
Don't show me.